challenges facing the employed bar. This event has been organised by the Bar Association for Commerce, Finance and Industry in conjunction with our colleagues at the Temple Employed Bar Forum. My name is Lawrence Fry. I'm an employed barrister working in the energy industry and a vice chairman of BACFI, and I have the pleasure of being the chairman for this event this evening. We're delighted that so many of you have joined us for what we hope will be an interesting and informative presentation. I'm sure you know the drill by now, but be very grateful if, to avoid background noise, you could stay on mute, unless, of course, you're speaking. To ask a question, please either use the chat facility on Teams or send a message, or just speak up when we get to the Q&A part of the evening. The webinar is being recorded for the BACFI website, and the slides will be available from our secretary Sandra, who's on the meeting this evening after the event, if you'd like a copy. Sandra, will that be on request, or will you just simply send them to everybody who's registered?
I will send them on request, and they'll be available on the website. Very
good, thank you. We tend to sort of take about an hour at most for these events, so we'll aim to finish around about 7 p.m. We have two excellent speakers for you this evening to help us explore the challenges facing our employed bar members. Our first speaker will be Dr. Alan Brener from University College London, and then we shall hear from Charlotte Pope-Williams, who's an employed barrister working as an associate with law firm Pinsent Masons, and Charlotte's also a member of BACFI's organising committee. So without further ado, I'll introduce our first speaker. Dr. Alan Brener is a lecturer at University College London's Laws Faculty, and he's also Deputy Director of the faculty's Centre for Ethics and Law. Besides his LLM from UCL and a PhD from Queen Mary University London, he's also a chartered accountant, and he's a member of the Institute of Chartered Accountants in England and Wales. Prior to starting his PhD, Alan worked for Santander UK and was responsible at different times for the compliance and retail legal departments and regulatory policy. Before joining Santander in 2005, from 1996, he headed the compliance departments for the retail banking divisions of NatWest and RBS. From 1989 to 1996, Alan was a senior prudential and conduct of business regulator for the insurance and collective investment sectors, having previously worked on aspects of public policy at the Department of Trade and Industry. Most recently, prior to starting his PhD, Alan was on secondment from Santander, helping to set up the Banking Standards Board with the objective of improving standards of conduct and professionalism within the banking industry. So over to you, Dr.
Thank you, Lawrence. Let me just share my screen. Right, well, hello everyone, good evening, and thank you very much for joining. I hope you can see my slides and also hear me. The key issue that I found over the years is that it's been really difficult for let's call it boards, non-exec directors, compliance directors, simply to find out what is going on within an organization. In my experience, whenever there's been a problem, there are a number of people who have known about the issues, but have either kept silent or had their voices quashed at an early stage. And if the information has sort of percolated up through the organization, those who received it have declined to hear it or have delayed action. And the same thing has actually happened within the compliance departments in their own way. They have seen themselves in many cases as being technicians, and they are in many ways the last to hear about issues because they have been less connected with the organisation than they should have been. They've tended to keep their heads down. Part of that is that the businesses themselves have tended to regard the compliance operation as being some form of business prevention unit, and that's in some cases reinforced by the compliance approach to things. The key element to a business succeeding is being trustworthy, and that the risk functions and the compliance functions must have sufficient authority within the organisation. Authority comes from really two particular sources. The organisation can bestow that authority on the risk function, on the compliance function. They can allocate sufficient resources. They can have the right reporting lines. There are a whole series of ways it can be done. And in addition, the other route is that the individuals within the compliance unit, including the compliance officer, must have their own innate capabilities which demonstrate that level of authority. The individuals in the compliance department need to clearly have integrity and be dynamic and curious and persistent and never let things go. If any of these things fail, nothing else will work. Compliance also needs to take a strategic view, and in many cases, as I said, the compliance departments in many areas have kept their heads down and not looked to engage with the business in terms of its business model, its strategies, and it's these elements that are critical to increase engagement by the compliance department in what is going on. Compliance need to continue to reflect on what they are seeking to do, because otherwise they ossify. And at the same time, compliance should look at other ways of doing things, such as new technology and use of artificial intelligence. Most importantly, the role of compliance is to change and develop the right culture and individual ethics in the business. If these do not happen, nothing else will work. One of the issues in many businesses is that they operate in complete silos. Individuals will not tell people sitting next to them what they are doing if they are in a different silo. Information is kept secret, and it is seen as being valuable as part of, let's call it, the office politics. At the same time, the risk functions and particularly compliance have tended to develop sort of standard procedures and formalized procedures for doing things. This is not a problem in its own right, but it can be one if it becomes ossified and fails to generate the right actions. The Financial Conduct Authority, because I look at things in my own perspective from my background in financial services, has tended to focus in recent years on the firm's business models, quite rightly. And they've been looking at the firm's purpose, what is it trying to do, its governance, and the extent to which the leadership reduce harm. The focus has been in many cases on high growth strategies, low and rapidly declining profitability, cross subsidies, because these elements can generate the wrong incentives inside organizations, and the compliance functions should be doing the same. There's also a key issue in terms of the extent to which the board and the senior management perceive their own personal accountability, and to what extent they put in barriers, one of them being the 3 lines of defense that I'll look at a bit later on, to, let's call it, limit information coming to them for their own personal protection. The FCA, as I've said, will look at what are the drivers for misconduct, and they found in many cases that it's poor culture, and a lack of individual accountability. These are particularly prevalent, as I've mentioned earlier, where you have highly competitive markets and you have firms on the verge of failure, because these extremes can often drive management to set targets which encourage misconduct and incentives which encourage wrongdoing. The senior management in all of these areas need to look at how strategy is actually perceived by the staff within the organization. I have an example which I've often used, which is the Wells Fargo bank case, where the senior management set a strategy for cross-selling of financial products to their customers. And their cross-selling was based on the fact that the more products customers have, it's better for the profit margins of the business. And in most banks, customers may have 2, 3, 4 products, credit cards and mortgages and so on. But in Wells Fargo, the strategy was to go for 8 products. Some people said that's because 8 rhymes with great, and that was part of the sales pitch the senior management made to analysts. However, they failed to see that that particular business model, that particular strategy, would be interpreted by staff in the bank branches as being a call to arms, and it's the case that bank staff actually started manufacturing products for customers. The customers either didn't know they had this product, or the customers in some cases didn't even exist. And that level of incentive, that particular strategy, drove the wrong behaviors all the way through. The other issue is that, and that's particularly brought out in the Wells Fargo case, but there are many others, that compliance saw themselves as being a technical function. They provided advice. Some legal departments have the same perspective. They provide advice and then walk away from how that advice is either rejected or implemented in practice. And compliance staff, need to be active in terms of what they actually do. They need to be involved with the board, very close to the board, and with strategic decisions. The compliance officer should sit on the executive committee. The head of risk in the appropriate organizations should be a main board member. There's a tendency in some compliance areas that they will just focus on regulation, the detail of regulation, and many compliance officers love doing that because they find it very fulfilling. However, it provides, in many cases, the illusion of compliance where the business goes on working much as they did before. There are a number of operational tools which can be used to remedy these issues, particularly the lack of knowledge of what is actually going on. One of them I call the directed telescope. It's one which comes from the Prussian general staff from 1866 during the Prussian War with Austria. And as you may know, the Prussian corps, the army corps, were each commanded by a prince of the royal blood, and they did not take kindly to getting orders from the general staff. In fact, they would keep information to themselves and would do whatever they wanted to do and disregard the instructions that came from Berlin. So the German general staff, the Prussian general staff, took the steps of implanting within each of the army corps the young, enthusiastic officers who were there to find out what was going on and to report it back to the general staff. The general staff looked upon this as being their directed telescope because they could see right into the depths of each individual Army Corps. There's similar ones such as the spider's web, but all of this requires compliance getting out and making contacts and developing informal systems of information, as well as the more formal reporting lines. The business clearly needs to consider all the stakeholders, and it's important that the compliance function do the same, and also understand the operations of the business in some detail. It's really important, and I found this as well in my role as a compliance director in a couple of banks, that you recruit people who come from the operational side of the businesses to make certain that you understand what's really going on. There can be particular problems with legacy systems, and they tend to get neglected. And there's an issue, as I've said, in some compliance departments, that they will keep their heads down and not look above as to what's actually happening. It's really important that compliance departments look over the horizon at the future, what is coming towards them, maybe 2, 3, 5, 10 years out. These are what I call the upstream risks. One of the issues, again, I found is that many large organizations have a high level of inertia. And that's brought about for a range of reasons. But one of them is that where a problem is found, quite often it's left fester. And it gets worse over the weeks, months, years, with no one taking ownership. And part of that is because no one wants to be held accountable, but also it means devoting part of your resources, your budget, and people will bicker over this and not take action. It's really important that the compliance department are there to make certain that people do take ownership and do take action as quickly as possible. And if all else fails, it is incumbent upon the compliance department to take on an operational role to make certain the issue is addressed quickly themselves. This will come as a shock and be counterintuitive to many compliance departments, but it is a key role because otherwise things will go wrong and be allowed to continue to be wrong. Culture itself is so critical. If the culture of the business is wrong, then everything else will be wrong. And in particular in regulation, it will be ineffective. The phrase I use is culture eats regulatory compliance. And it's important that both the business and the board, non-executive directors, are heavily involved in the measurement of culture. And again, compliance has a role there too. There are all a whole range of ways of measuring culture. There are indicators I've used in terms of looking at staff illness, short, long-term illness, repeated people going on away on sick leave repeatedly, staff training, who participates, who doesn't, who misses training sessions, and so on. These can be used as indicators. It's important that the information is not aggregated. Anthony Saltz, when he did his review of Barclays, found that when information provided in terms of bank culture to the board was completely aggregated, and all the indicators were all green, because you have let's call it a convergence on the mean. And what you're really interested in is the extremes. And you look at a trading desk, a particular team, even down to a team of about 10 people. That's probably the lowest number, but you can see that. So that if you do a RAG status, a red, amber, green assessment across all the various factors, you can very quickly spot particular problems at a high level of detail. And particularly the case if you look at the staff engagement surveys, because these give you a clear indication of issues and where you need to spend your time. One of the problems I've seen with some senior managers in a range of areas is the ability for self-delusion. It's possible to rationalize problems, It's possible to ignore them. It's possible to use the language of euphemism. Again, Wells Fargo is a classic case of the use of euphemism in its interpretation of everything that went wrong. And there's a sense in many cases that some senior managers do not want to hear bad news, and that only good news will percolate up. And this element of everything being sunny, wishful thinking can permeate many organizations. I come towards the end now, and one I just want to mention briefly is the so-called 3 lines of defense, which is quite common in many financial services firms. It's been widely adopted. I think it was propagated by a number of consultancy firms. On the face of it, it sounds conceptually attractive, and if you want, if anyone's interested, I can explain the conceptual approach. However, I've never used it, I won't use it, and the Parliamentary Commission on Banking Standards, when they looked at this, they thought that the 3 lines of defence provided a wholly misplaced sense of security. Much of the system became a box-ticking exercise whereby processes were followed, but judgment was absent. The same report stated that the 3 lines of defence was also promoted the use of an accountability firewall behind which senior management and the board could cower because they could deny knowledge because of the, let's call it, the lines of defence that prevented them knowing anything or knowing anything of importance. This is an anathema to how compliance should operate. It must be engaged. It must know what's going on, and it must report its findings clearly and without hesitation, and it must take action. Just a couple of examples that you might want to think about. Alliance and Leicester Bank in the 2000s was selling or mis-selling payment protection insurance, and it adopted a mode of selling called the pressure cooker effect, and it actually had a document telling its staff how to use these pressurized sales methods. For reasons that escape me, the compliance department actually signed off this document, and it led to action by the regulator in terms of a hefty fine on Alliance and Leicester. Other cases are MoneyGram International, where the compliance officer made recommendations to management to discipline and terminate fraudulent employees at the firm, but was overruled, and the compliance officer failed to take any action. In another case involving the Bank of Beirut, its UK business, the compliance officer failed to be open and honest with the regulator. He claimed that at the time he felt under pressure from senior management to be careful in his communications with the regulator, and that he had not been given license to explain the issues fully to the authority. Well, clearly the regulator wouldn't accept this at all. It's a wholly wrong approach. I'll just sum up. The issues are clearly integrity, the compliance officer and the compliance staff having sufficient authority, clearly the right culture, how it's measured, various techniques to find out what is going on, the directed telescope, action, do not delay, the avoidance of hubris and self-delusion, particularly at the senior management, the executive committee and the board level, close working with other risk functions, close working with the board and non-exec directors, and understanding the regulator and their concerns. Finally, as Lawrence mentioned, I'm Deputy Director of the UCL Centre for Ethics and Law, and we have a website, and when you get the slides, you'll be able to click through, hopefully, and find our website. And finally, I've been permitted to plug my latest book, which I can hold up over here, which is on strategies for compliance. And I'm doing a book launch on online on the 10th of May, if anyone wants to attend that. I'll leave it open to questions. There's a picture of Nikki Morgan, who was head of the Treasury Select Committee, and interested in your views. Thank you very much.
Alan, thank you very much indeed. I know a lot of our members are in compliance functions, so I'm sure they found that really interesting, and I particularly enjoyed the tools for compliance that you highlighted, and I'm certainly interested to have a look at your book. If I may just kick off with one question. I didn't quite follow the 3 lines of defence that you mentioned. Could you just elaborate on those again for us, please?
Yes. The 3 lines of defence is a concept behind compliance where you have a first line, which is the business line, and the business line will have some form of compliance operation built within it. And the idea is that the business will take responsibility for compliance at the front end, and that their own local compliance reporting locally will act as some form of check and balance on what they do. The second line is the compliance department itself, which is there to carry out monitoring and checking that the business line, the first line, is doing what it ought to have done. And then the third line is internal audit, reporting direct to the board. So those are the 3 lines of defence. Conceptually, not an issue, but in practice, companies aren't really organised as neatly as that.
No, indeed. So I'll throw the floor open to any questions, either on the chat function or if anybody just wants to speak up, that would be also very, very welcome. You've stunned them all into silence.
Yes, it sounds like it, yes. Anyway, anyone who wants to follow us up, delighted to do so. You can always find me quite easily, and very happy to talk things through. Very good. In that case, if there are no questions at this stage, we will move on then to our second speaker. And our second speaker this evening is Charlotte.
I'm not sure if Lawrence has frozen for me. I hope.
Pope Williams. Charlotte was called to the bar in 2011. She undertook pupillage at a leading set of London chambers, specialising in commercial. Oh, sorry. Can you hear me? So I think I got as far as saying that Charlotte pupillage at a leading set of London chambers, specialising in criminal law. She subsequently posted in the Bank of England's legal directorate, where her career highlights included, but are not limited to, working on the Prudential Regulation Authority's £14 million fine of RBS, working on the first ever Sharia compliant facility formerly contemplated by a Western European Central Bank, and thirdly, working on a transition away from LIBOR. Charlotte is currently in private practice at Pins & Masons, where she specialises in financial services disputes. Charlotte has been elected a member of the Bar Council since December 2014. She currently sits on the Young Barristers Committee and the Employed Barristers Committee, where her work has included teachings on financial literacy for junior practitioners and pushing for insurance cover for employed barristers so that they can undertake pro bono work through Advocate, formerly known as the Bar Pro Bono Unit. Charlotte also currently sits on the COMBAR Equality and Diversity Committee and mentors individuals at various stages of their careers, particularly those with protected characteristics as defined in the Equality Act 2010. So Charlotte, over to you.
Thank you very much, and thank you for listening to me today. I know that I am the only thing that stands between you and dinner, so I will try and keep it succinct and interesting at the same time. So why am I speaking about ethics in particular? The reason why I think I have some useful expertise is because, as you've heard, I've worked in the public sector. I currently work in the private sector. I have been self-employed. I am currently employed. I have worked for a regulator. As part of my day-to-day work, I look at regulatory conduct and misconduct across the piece, and lots of the individuals that I deal with are subject to multiple ethical norms. And so this is very much part of my lived experience, and also through my work with Bar Council. I have assisted in resolving ethical issues for employed barristers in particular, insofar as they come up. So I'll quickly talk about why you should be bothered about ethics, because the only way is ethics. And secondly, I'll talk about a few practical examples of ethical issues that might come up for those who are employed practitioners, whether they are registered or unregistered barristers in employed practice. So first, why should you be bothered about ethics? Well, because it's the right thing to do. Or is it? I know that the BSB, the Bar Standards Board that regulates barristers, whether unregistered or not, has come in for some criticism lately about both how the norms that it has that applies to barristers are enforced and interpreted, particularly in relation to harassment and bullying. Some of you may be aware of the recent cases concerning sexual harassment. There's a case where a barrister has been suspended for 3 months for harassing someone on 3 separate occasions, and there has been public outcry and outrage at the short nature of the suspension, and people consider that it's not a sufficient sanction for the conduct in question, particularly when compared to other regulatory environments. However, to be fair to the BSB, they did issue a statement on the 29th of January of this year, acknowledging that people might be dissatisfied about the way in which they have been exercising their enforcement powers in relation to harassment. And there is a consultation that is out at the moment, or well, that will be out shortly, for the BSB's sanction guidance, and that will come out at the beginning of April for 6 weeks. And I would really encourage practitioners to respond, whether it's with respect to harassment or bullying, or more generally how you are regulated as an employed barrister. This is an opportunity to have your voice heard and make a real impact and make change. So I would encourage you to do that. Why else should you be bothered by ethics? Because you don't want people like me coming after you in the commercial courts or otherwise. And the reason why I say that is because often codes of conduct and regulatory standards are deployed tactically as part of professional negligence type actions. So where someone may have breached a code of conduct, it may be evidence to suggest that they have not met the standards required when they're undertaking their obligations under a contract, or they're not exercising their powers or duties in accordance with the standard of care expected in that particular profession. So just keep in mind that it's not just the right thing to do. You can be in front of some very frightening people before various courts and tribunals, and facing lots of satellite litigation. Another element to consider for the professional negligence element of this is that, so I can see some messages coming up about their screen sharing going on. So I don't know. I don't know if we can, I think that's stopped now. So hopefully that's a little bit better. But the other element I was going to flag is professional indemnity insurance. So just thinking about, if there is a breach of any ethical norms to which you are subject, will your insurer be on risk? Has there been a fair presentation of the risk? where you're somebody that's subject to multiple different ethical norms, for example, if you need to make a claim, and if you're facing lots of satellite litigation as a result of something that's gone horribly wrong, which hopefully it won't for any of you in your practice or otherwise, just thinking about how you engage with insurers. A few nifty statistics that I think are important. With respect to the barristers profession, there are 53,430 unregistered barristers. And the reason why I flag that is because unregistered barristers are in the majority. The minority are practicing barristers with practicing certificates, so there are around 17,000 of those. But I did a little bit of a straw poll in and around the office and on Teams today, and many of the unregistered barristers within my own firm had no idea that they were in fact still regulated by the Bar Standards Board. And indeed, the Bar Standard Board does sanction quite a few unregistered barristers proportionately, albeit that in the year 2019 to 2020, out of those, try to do quick maths, just over 70,000 barristers, only 10 barristers were disbarred and 15 had findings against them. So that's not too many, but proportionately quite a few of those people were unregistered barristers. So it's just something to keep in mind. The BSB is always watching. It's always also important to keep in mind what you can and cannot do as an unregistered barrister. So you cannot exercise reserved activities under the Legal Services Act 2007 ordinarily. What you can do is practice as a foreign lawyer, so overseas, where you're not applying English law before the courts of England and Wales, unless you are regulated by another approved regulator by the Bar Standards Board. So, for example, someone who's regulated in a law firm by the Solicitors Regulation Authority would be able to carry out reserved legal activities in that setting, as long as they're not holding themselves out as a barrister or a manager in a BSB entity. So that's just something to keep in mind. So on to the more interesting section, which is the ethical scenarios that I would encourage you just to have in mind. And these are things that I've come across in practice and during my time at Bar Council that are worth thinking about when you're going about your day-to-day work, whether unregistered or registered. So the first are employed barristers who hold executive functions. Now, if you're carrying out legal activities, it's trite, you would properly expect to be regulated by the Bar Standards Board. Where it becomes a little bit tricky is where you're undertaking an executive function, but people happen to know that you're qualified as a barrister. Do the BSB Code of Conduct rules bite in that scenario? And a lot of people don't appreciate that they do. And this is becoming an increasingly difficult area, particularly where perhaps your company or organization may have done something that is now considered to be repugnant, morally repugnant or ethically repugnant. And in this era of social media, the tide can turn against you exceptionally quickly. In those circumstances, you may have reduced trust and confidence in the profession, or you may have brought the profession into disrepute where you endorse or sanction that type of conduct. And I note that in a case that I'm going to refer to a little bit later, that an unregistered barrister was indeed sanctioned for an interaction on Google and Google reviews. And he was considered to have reduced the trust and confidence in the profession through his conduct. So another common ethical issue that I find crops up is conducting litigation in innocence, as I'd like to call it. And this is particularly the case for more junior practitioners who may have just finished their BPTC, BPC or BTC, as it's now called, not the BBC, lest we get confused with our acronyms. they don't have their practicing certificates yet, but they've done some of their advocacy training, and they go and work for organizations that provide advocacy services to small and medium-sized enterprises, for example, where they go and do debt actions in the county court and such like. And go on their merry way. Another set of people who are caught out by the conduct in litigation rules are people like myself who work in law firms, employed barristers in law firms, who think that they can go along and conduct litigation without authorization or exemption. So super, super important that if you want to conduct litigation, you are authorized or you receive the requisite exemption. However, a sticking point is that most people have no idea what conducting litigation is, which is why they get caught out and find themselves before the BSB, particularly at the more junior end. So what is conducting litigation? It is defined in Schedule 2, Paragraph 4 of the Legal Services Act 2007, and there are 3 key elements which are nice and woolly, so difficult to put a pin on precisely what is meant by the Act, but those are issuing proceedings before any court in England and Wales, commencement, prosecution and defence of such proceedings, and the performance of any ancillary functions in relation to such proceedings. Completely woolly. So I thought it would be more helpful to give you a practical example, which is a decision by the BSB on the 24th of September 2020. And this relates to I'm going to assume, younger person. I like to think I'm a younger person too, but really I'm not, who was called in 2014. He fell foul of the prohibition against conducting litigation because he provided his name and address for service of claimant, the claimant being his client, and he filed and served a witness statement and evidence before Chelmsford County Court. The BSB reprimanded this young man and fined him £1,000, and he was an unregistered barrister at the time, and it would appear that he just completed his BPTC or had relatively recently completed his BPTC when the acts were going on. And this is also the gentleman who was considered to have brought the profession a reduced trust and confidence in the profession because he had been untruthful about a Google review. Because he instructed Google to remove a review about him and his services and stated to the BSB that he did not know the reviewer in question. It turned out that the reviewer was the opposing party to the claimant in the action where he had been acting before Chelmsford County Court. All that to say is that a lot of people would probably think giving a name and address for service is something that's quite innocuous, or filing and serving a witness statement or evidence, particularly at the county court level, doesn't seem like that much of a big deal, but it's certainly something that can cause you to come a cropper. And as we've seen, considering that there aren't that many people that do face sanction by the BSB, it's interesting that this is the type of conduct that they have been focusing on recently in September 2020. And it's also worth noting that to conduct litigation without authorization or exemption is a criminal offence subject to imprisonment or fine, although 9 times out of 10 it tends to be a fine from the BSB. The next most substantive issue that I come across most regularly in my practice is where employed barristers are subject to multiple ethical norms at the same time. And those norms sometimes compete and conflict with each other. So, for example, an individual might have multiple professional qualifications and or work in a regulated industry as well. For example, my favourite, financial services, you might be subject to the senior managers and certification regime. It does what it says on a tin. If you are a senior manager, you are subject to additional regulation, or you might be subject to the regulation of the Financial Reporting Council if you're a barrister, an auditor or actuary, an accountant, and you would be surprised how many people hold those multiple functions. Or if you're in a solicitor's firm, you may be subject to the Solicitors Regulation Authority Code of Conduct, Or if you work in a public service, you may be subject to the Civil Service Code. Or, as Nicola Sturgeon will be well aware, you may be subject to the Ministerial Code. And I say that because Nicola Sturgeon read law with one of my colleagues and is a qualified solicitor, so subject to multiple ethical norms. Or you may be subject to Military Code of Conduct. So the Army has the Army's Value and Standards and an Army Leadership Code and the Service Test to decide whether they take disciplinary action against someone or have a hearing in that regard. And finally, and this set of guidance relates to the case I'm going to talk about very shortly, is you might be subject to medical ethical guidance as well. So the General Medical Council's codes or the Nursing and Midwifery Council's codes. And the reason why those are just a few examples where if you have multiple qualifications, you can be subject to multiple ethical regimes. And particularly now in the 21st century, lots of people have portfolio careers. They'll start doing one thing, they'll continue to do something else, or they might do several things at the same time. And what they may not appreciate is that they are being subject to multiple norms and things can go wrong and they may come a cropper. And there's a recent case which is quite interesting in that regard. That's quite instructive, and it's a judgment by Mr. Justice Eadie, and the case is Ogun Sanya and the General Medical Council. And Mr. Ogun Sanya is a solicitor advocate and a general practitioner at the same time. And whilst he's obviously not a barrister, the judgment is equally applicable to anyone that's subject to multiple ethical norms. So the facts of the case are that Mr. Ogun Sanya was instructed by two doctors whose contract had been terminated by NHS England and they wanted to appeal. They were also subject to suspension by the Care Quality Commission as well. So Mr. Ogun Sanya was appealing the NHS England decision and also the Care Quality Commission decision on behalf of those medical professionals. And then things went a little bit wrong for Mr. Ogun Sanya, because as a doctor, he went into the surgery for his clients and had a discussion with another medical practitioner about what his clients could and could not do. And the doctor in his client's surgery said that his clients could continue to provide medical support and caretaking in the surgery if and until things were sorted out with the Care Qualities Commission and NHS England. When Mr. Ogun Sanya appeared before the Care Quality Commission Tribunal and the first tier tribunal, it turned out that the doctor in the surgery denied that he had any conversation with him. So you had a conflict between the advocate, the witness, and the presentation of the case on behalf of the claimant, and there were some real issues there. And so Mr. Ogun Sanya's conduct was impugned and called into question by that doctor that said that he hadn't been truthful before the first tier tribunal, and a complaint was made to the General Medical Council, who started an investigation. Mr. Ogun Sanya was not satisfied and was unhappy about that and decided that the GMC did not have jurisdiction to decide what he could and could not do before the first tier tribunal in relation to the Care Quality Commission, because he said he was acting in his capacity as a solicitor advocate. He was not acting in his capacity as a general practitioner, and they had no authority to decide or investigate that which he was doing. So he sought injunctive relief and declaratory relief in the High Court by issuing a Part 8 claim against the General Medical Council. And what's interesting here is what Mr. Justice Eadie said in his judgment, particularly at paragraphs 10 and 11, and it's quite short and pithy, and at paragraphs 38. Oh, I can see someone's email on the screen, and I don't think I meant to. And paragraphs 38 and 39. First, he spoke about what professional misconduct would mean for the purposes of the General Medical Council's jurisdiction, which isn't civil war and revolution in England. Indeed, professional misconduct for the purposes of the GMC is anything that has a nexus or proximity to Mr. Ogun Sanya or other medical practitioners. Oh, we've lost that now. Is anything that has a nexus to medical practice. Sorry, I shouldn't giggle in the middle of a presentation. It's very unprofessional. So it can involve anything where someone is morally culpable or otherwise disgraceful, and it might occur outside of your professional practice, but it might bring disgrace upon the profession of a doctor and therefore prejudice the reputation of the profession. And that equally applies if you're a barrister or solicitor or in any other profession. So professional misconduct for the purpose of these types of codes of conduct are quite broadly defined. Moreover, at paragraph 38 and 39 of the judgment, Mr. Justice Eadie said, right, if you are subject to multiple regulatory norms, then it is perfectly legitimate for you to be subject to the jurisdictions of multiple tribunals at the same time in relation to the same facts. And it may well be that you're subject to several investigations at the same time, and you may be subject to sanctions by several regulators for the same set of facts. And we see that happening in any event in other areas, particularly in financial services, where the Serious Fraud Office may take an action, which will be followed by the Financial Conduct Authority taking an action by way of example. But again, it brings into sharp focus that professional negligence piece. It brings into sharp focus the professional indemnity insurance piece, because if you are employed by a doctor's surgery, but you are being pursued for something that you do as a solicitor advocate, and the professional indemnity insurance is for your doctor activities, at what point is the insurer on risk? Are they on risk if something goes wrong in that regard and you're being pursued by the Bar Standards Board or the Solicitors Regulation Authority? Another interesting point from that case is that Mr. Ogun Sanya has also issued a Part 7 claim against the General Medical Council for unlawful interference with his trade and practice as a solicitor advocate. His argument being that the GMC exercising its regulatory powers and investigating him is prohibiting him from being able to carry on his practice as a solicitor advocate. And we could see that happening for a barrister as well. So it's one to wait and watch and see what happens with respect to Mr. Ogun Sanya, because Mr. Justice Eadie considered that there was a case to argue, so he's been allowed to proceed in 2021. And the last point, I can see that I'm almost out of time, and one that comes up a lot is, what do you do if you're an employed barrister, you give advice and your employer or organisation is not minded to follow it or does not agree? And whether you are registered or unregistered, the core duties still apply, and you must act fearlessly in the best interests of your client, irrespective of the consequences for you. And that applies even when you're an employed barrister. Your independence is paramount, and sometimes that can put you in a really, really sticky wicket. It can make you extraordinarily unpopular in your organisation and in practice. I can see that has put people in difficult positions. For example, you may be less likely to get your promotion because you didn't toe the party line. You didn't suffer from that inertia that Dr. Brener mentioned before. The only concluding remarks that I will make, because I am almost out of time, is that you can get support from the Bar Council's Ethic Hub, which you can find online on the Bar Council's website. You can just click through. There are a series of articles, and I am on a working group that's working on providing more guidance to employed barristers. But the more you make use of the Ethics Hub, the more material will be produced for registered and unregistered practitioners. And also it's worthwhile reaching out to specialist bar associations like ourselves at BACFI, where you have questions we can perhaps direct you in the right way, or Commercial Bar Association, etc., where you have a particular practice area. And that's all I have to say, because there isn't enough time, but happy to to try my best to muddle through any questions that you might have.
Charlotte, many thanks. That was fantastic presentation of the issues that we're facing. I think in particular that the point on independence is really important, and one that I've seen in my own practice, where ultimately, a general counsel may have to resign if he's not being listened to, and I've seen that happen. But that's a brave course of conduct these days. So I'll throw open the floor to any questions.
Well, can I mention also senior civil servants who throw in the towel as well? Elizabeth Wilmshurst in the Foreign and Commonwealth Office over the Iraq War, and more recently Jonathan Jones over the government's proposal to defy the Northern Ireland agreements. It goes on. Yeah.
Thank you, Tricia. Yeah, indeed.
I can see Ediz, I hope I pronounced your name correctly. I can see you've got a hand up.
Yes, hello. Is that coming through?
Yeah.
Okay. I've got two questions. Apologies in advance, Dr. Brenner. I wanted to make sure both speakers spoke just in case there was a question that overlapped between the two. So I've got a question, one for each of you, if that's okay. So I'll start with the one to Dr. Brenner. So my question, sort of in terms of compliance, is what do you do in terms of the culture if there is, for want of a better word, a high push from upper executives against a sort of a positive sort of culture towards compliance? What would be the best sort of action for a compliance officer to do in that position? Would it be to say leave that particular firm, or to try and push externally for change within that company?
Okay, yes, a good question. The first thing is you need to think very long and hard about whether you should join that organisation. If you are thinking of joining that particular firm, you need to do your research and get some sense as to how they work. But let's assume that you are in place and there's a change in management and policy. You've got a whole range of ways of influencing what goes on. Ultimately, you have an Armageddon power. Okay, you have the right and actually a duty, talked about codes of conduct and the senior management regime, to actually report whatever is going wrong to the regulator direct. It's not only because it's the right thing to do, but it's also for your own protection under that particular regime. But you have a whole range of steps that you would go through first. You would obviously talk to the line manager, the chief executive. If those individuals didn't take on board what you were going to say and implement it, then you've got the chairman of the Audit and Risk Committee. They will be almost certainly a non-exec director, and they have their own responsibilities as do the others. And if that all fails, then you've got the main board chairman. These individuals will be very, very conscious of both their institutional responsibilities and their personal responsibility as well. Hopefully, before you get to the Armageddon approach, these individuals will have all acted properly to do the right thing. I described it as being very much what I call the sheathed sword. They know that you have that power, and you need to be able to make certain that they know that you will use it. But the expectation is that they will all do the right thing well before you get anywhere near that. But there are other people in the organisation who will all work with you to make certain the organisation does the right thing.
Thank you. And the question I had for Charlotte, well, it related to one of the initial points you'd made, in particular with claiming within the BSB. So from what I understand about the process of ethics when you're a barrister claiming, you first rely on say the incident happens, you look at a senior barrister or another sort of member within the sort of council for advice on a particular issue and a particular incident that's happened. You then refer to the BSB handbook, which is non-binding guidance for the ombudsman. And then after that, you can look at towards the helpline they have for the BSB. And then past that point is when sort of action would then take place. My question to you is, do you think the sort of range of steps that's used as guidance is a hindrance or a benefit in terms of getting both one claims successfully through, because obviously you're putting that standard onto the barrister themselves to find that evidence to make a substantial claim, and also in terms of the sense, for want of a better word, sentencing that's then provided for particular claims?
Right. First, I was going to make a quick comment in response to your question to Dr. Brener, which is I'd always advise people to insulate themselves by creating an audit trail. Get your advice endorsed. Make sure that if you are not in full agreement with your seniors, that there is a written record of that which you have said, in order to insulate yourself going forward, because often these types of conversations happen orally, or there isn't any kind of record. Then you'll find yourself, particularly at the more junior end, being thrown under the proverbial bus. So that's one practical consideration that I would really endorse wherever you are. Just make sure you have the right type of audit trail. As regards the BSB processes and the like, I consider that there is always room for improvement, is the diplomatic answer that I would give. And insofar as articulating how that improvement should happen, please do respond to the BSB's consultation. But I also say sometimes people forget that you can leapfrog depending how serious an issue is and go directly to your regulator in the same way that you would do in any kind of financial services type scenario, where you have sort of the whistleblowing type element where you just go directly to regulator because something is so very serious that action needs to be taken. But I'm aware that the standard for the BSB has changed from the criminal reasonable doubt to the civil. I would hope that that would make it easier with respect to the regulation and the consideration of claims. But certainly I sympathise greatly with some of the public sentiment about how certain types of cases are being dealt with, and I look forward to improvement in that regard by my regulator.
Thank you.
Thanks.
Thank you. Those are very good questions. Anybody else? We're sort of just creeping past 7 p.m. and people will be drawn to their cocktails and dinner. But I think we've got a few more moments to invite any other questions. I don't see any hands up or any messages, so perhaps we've run out of time now. I think people probably want to move on. That concludes our presentation. I hope you'll all agree that it's been a fascinating insight to a number of ethical issues and challenges facing employed bar members and their colleagues. Would like to thank very much our really excellent speakers, Alan and Charlotte, also our secretary at BACFI, Sandra, for kindly organising the administration for this event, and as we said earlier, Sandra will provide slides upon request. I think also, Sandra, people can sort of play this back on the website, is that right, or is that is there some other link you need to send for that?
I have recorded it, and it will be on the website within a week or so. Yes. Very good. So I hope you come away from this evening endorsing our view that the only way is ethics. And if you've enjoyed this event, we do run a series of events at BACFI. You can find the information on the website. I won't run through them now, but we have a sort of wide-ranging and varied number of topics that we cover. And if you're not a member of BACFI, but we've whetted your appetite to find out what we do a little bit more and get involved,
you're very welcome to join us. And again, information on the website is available all through Sandra. So I'm going to bid you all a very good evening. Thank you so much again for joining us, and we'll see you next time.
Quick question. Oh, sorry.
Sorry, you had another question.
Quick question. What email address do we send the request for the PowerPoints?
Can you send it to secretary@bacfi.org?
Okay.
Very, very good. Unless there's any more, I'm certainly going to leave now. I think my cocktail is getting a bit warm. So thanks again, everybody. Take care.
Thank you.
Bye.
Thank you.